Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's video. On today's video, we're continuing with our new series entitled Prove the Complexity Factors. And today's video is session number 2 in this new series. Now, in the first session of this discussion, we talked about recent changes in the complexity factors as those are described under California Code of Regulations 9795, and it seems that there have been some recent changes in both the interpretation and the actual language of the law under CCR 9795. So historically speaking, we went through a period of time of about 1 year duration where we lived under a new interpretation, the Division of Workers' Compensation's new interpretation of the complexity factors without formal change of the language of the complexity factors under law, under CCR 9795. Well, we lived under that oppressive regime and oppressive interpretation for about 12 months until just very recently when there was a QME settlement agreement in April of 2018 wherein we had those new interpretations reversed. So we were allowed to go back to our former style, mode, and manner of billing for the complexity factors for our reports. Well, since then, since the QME settlement agreement, there have been a couple of additional new changes, and it seems that the complexity factor issue is something that we're going to be living with at least for the immediate future. Since the April 2018 QME settlement agreement, it seems that simultaneously, while the Division of Workers' Compensation was agreeing to the QME settlement agreement, they were also simultaneously drafting changes to the language of CCR 9795. And right now, as this video is being recorded, we're in the middle of a 14-day public comment period wherein the public has an opportunity to comment on the new changes, on the new proposed changes to the language of CCR 9795. So I encourage you before May 18th, 2018 to go onto the DWC's website and voice your opinion about the new proposed language, the new proposed changes to the medical legal fee schedule. Now, the new proposed changes to the medical legal fee schedule are even more oppressive than even the prior new interpretation of the complexity factors that we just had reversed with the QME settlement agreement. So the new proposed language virtually guarantees that no report could possibly qualify for an ML 104 billing level because it seems that the Division of Workers' Compensation has basically blocked the use of every complexity factor and has made it extremely difficult, if not impossible, to qualify for even a single complexity factor. Now, it's my opinion that the Division of Workers' Compensation's new proposed language simply represents their attempt to swing for the fences and to try and obtain or attain every single consideration that they could hope to attain in an ideal world. Well, since the Division of Workers' Compensation has proposed their new language changes, the lawyers in Los Angeles who arranged the QME settlement agreement in April 2018 have forwarded their own counter language to the medical legal fee schedule. Isn't this amazing? There's so much activity going on related to the complexity factors that it's difficult to even keep up on a week-by-week basis. Well, as equally oppressive as the DWC's new proposed language is on the one hand, the equally liberal is the counter proposed language by the Los Angeles law firm. So it's my opinion that we're probably going to settle for some language somewhere in between the two extremes of the two parties, the Division of Workers' Compensation's proposal on the one hand and the Los Angeles attorneys on the other hand. Well, it's not clear where we're going. So what is clear is that now more than ever, and in the future more than ever, it's going to be extremely important that whatever complexity factors you are able to employ in your evaluation reports, it's essential that you be able to prove that your report qualifies for the use of the complexity factors. Because the whole snafu, the whole problem, the whole controversy that we're now experiencing traces back to qualified medical evaluators misusing, misemploying, and misrepresenting the complexity factors. In other words, qualified medical evaluators were billing for complexity factors that they did not employ in their report. And this angered the Division of Workers' Compensation, rightfully so. This rightfully angered the Division of Workers' Compensation, and they retorted by changing the interpretation and now changing the language of the complexity factors to make it extremely specific on the one hand and extremely difficult on the other hand to qualify for the use of each and every one of the complexity factors. So if you're going to employ complexity factors in your report under ML 103 and under ML 104, you're going to have to be able to prove that your report qualifies for the use of those complexity factors. And we stated two basic points in video number 1, session number 1 of this program. And that is, number 1, the necessity of being able to prove your use of the complexity factors within the body of your report so that every single party that reads your report agrees that your report qualifies for the use of those complexity factors. So that's number 1. And then number 2, that those sections of your report that deal with the complexity factors are the most important sections of your report. So let me give you an example. Is the physical examination of the examinee a complexity factor? In other words, if you examine one body part compared to examining 10 body parts, does that qualify as a complexity factor, your physical examination? Indeed, the physical examination is complex, but that's different from a complexity factor. The physical examination is not a complexity factor. So the physical examination section of your report is a section of your report that you can tinker with and you can experiment with in finding formats for the physical examination section of your report that are shorter and shorter and shorter and get the same message across to the reader as a longer or more lengthy physical examination section of your report. Conversely, the review of records section of your report qualifies as a complexity factor. Conversely, the causation section of your report qualifies as a complexity factor. The apportionment section of your report qualifies as a complexity factor. Therefore, these sections of your report, the review of records, the causation, the apportionment, and other sections of your report that deal with the complexity factors have to be absolute masterpiece, fabulous sections of your report. Think like the reader of your report would think. When the reader of your report looks at your use of the complexity factors for which you are billing the report, what's the reader of your report going to do? Automatically, and just by default, just because human beings are curious creatures when it comes to charges and expenses, by default, the reader of your report is going to go right to those sections of the report to see why it is that you're charging for the complexity factor. And if you employ causation as a complexity factor, shouldn't the causation section of your report be substantial? Shouldn't it be exhaustive? Shouldn't it be comprehensive? Shouldn't it include a thorough discussion of causation that answers all the questions in dispute of the parties? Shouldn't the opinions and conclusions in the causation section of your report qualify as substantial medical evidence? Well, the answers to these questions are yes, yes, and yes. And specific criteria are required, and our specific criteria are essential for you to be able to prove that causation qualifies as a complexity factor. Many doctors in the causation section of your report simply include a one-sentence discussion, which basically includes the following few words. They say that causation is work-related. 4 words. Causation is work-related. And they feel that that discussion, that 4-word discussion of causation, qualifies causation as a complexity factor, and it's the Division of Workers' Compensation's position that it does not. So in today's video, we're going to talk about how to prove that your use of the complexity factors actually qualifies as a complexity factor. See, the two are different. Billing for a complexity factor and discussing those issues do not necessarily qualify as a complexity factor. Each of the complexity factors has specific criteria that have to be met, and I'm here to tell you that the specific criteria are toughening. The specific criteria are tightening. The specific criteria are becoming more and more altitudinous, if that's even a word. It's becoming a higher and higher threshold to be able to qualify for the complexity factors. So it's essential that you prove to the parties that your use of the complexity factor qualifies as a reimbursable complexity factor. So today, in today's discussion, I want to talk to you about the complexity factors that you can deal with prior to the face-to-face evaluation, and the complexity factors that you can set up in your report even in advance of the face-to-face evaluation with the examinee. So let's talk about those complexity factors that can be handled even in the absence of the examinee. And those include, number 1, the causation complexity factor, and number 2, the review of records complexity factor. Okay? So many doctors employ causation as a complexity factor, and many doctors employ review of records as a complexity factor, and they're doing it incorrectly. And their use of causation and their use of review of records does not actually qualify as a complexity factor. And so the claims administrators are not paying for these complexity factors. And the Division of Workers' Compensation in the past, even though they've been prohibited from continuing with this practice, but in the past have issued disciplinary measures against qualified medical evaluators for misuse. In other words, failing to prove the use of the complexity factors. So causation and review of records are at least 2 of the complexity factors that can be established even prior to the face-to-face evaluation with the examinee. So let's talk about causation as a complexity factor. Now, the current language following the QME settlement agreement, so the current language that's in effect with regards to causation as a complexity factor simply states that causation as a complexity factor applies when the physician addresses causation upon written request of the party or parties requesting the evaluation, period. That's all. When you discuss causation upon written request of the party or parties requesting the evaluation, that qualifies as a complexity factor. And in my opinion, this language is quite generous, is quite liberal. As long as you have a written request from one or more of the parties to address causation, you can go ahead and address causation and do a fabulous job in the causation section of your report in answering all of the questions that the parties pose to you in their cover letters, and you can be assured that causation will apply as a complexity factor. Now, the language to the causation complexity factor is expected to stiffen and tighten considerably if the Division of Workers' Compensation's new proposed language indeed does pass. Now, on the other hand, the Los Angeles lawyers, they have proposed a return to a prior, more liberal description of causation as a complexity factor, which used to state, addressing the issue of medical causation upon written request of the party or parties requesting the evaluation. So that's the same language as we currently have. So it used to state the same thing, but then there used to be a comma. And after the comma, it said, or, meaning that there now are two criteria for causation. It said, or, comma, if a bona fide issue of medical causation is discovered during the evaluation. So let me ask you, under the prior, more liberal language, which the Los Angeles attorneys are suggesting that we return to, under the prior, more liberal language, who is it that discovers a bona fide issue of causation during the evaluation? Of course, it's the qualified medical evaluator, correct? So the prior language, which allowed for the use of causation as a complexity factor when a bona fide issue of medical causation is discovered during the evaluation, the former language used to give the authority for invoking medical causation as a complexity factor to the qualified medical evaluator. So the qualified medical evaluator had the authority, even in the absence of a written request from the party or parties, the qualified medical evaluator had the authority to invoke causation as a complexity factor simply by discovering a bona fide issue of causation during the evaluation. Well, it seems that qualified medical evaluators misused and abused that authority and employed causation in every single evaluation, even when there was no bona fide issue. So the language of causation as a complexity factor changed and tightened to involve only those circumstances when we received a written request from the party or parties requesting the evaluation. In other words, the authority to invoke causation as a complexity factor by the QME was removed, was eliminated, was deleted, and the qualified medical evaluators no longer had the authority. They could only attain or obtain the authority from a written request from the party or parties requesting the report. Well, I didn't have a big problem with that because most times, most cover letters contain questions related to causation. In most cases, involve disputes over the many different phases of medical causation. So when you get your cover letters from the parties, you're going to scan and review those cover letters for causation questions, because it's the causation questions that provide your authority. It's the causation questions that qualify as the written request from the party or parties requesting the evaluation. So I have here in front of me pages from 3 separate and distinct cover letters. These involve 3 separate and distinct cases, and I haven't reproduced the entirety of the cover letters. I simply reproduced the pages of each cover letter that contain the causation questions. So let's just review these in order to give you an idea of the many different flavors and the many different faces that you can expect to find causation and requests for causation in the cover letters that you receive. So here's a cover letter. This is page 1 of the cover letter. It gives some historic background in the first couple of paragraphs. And then starting in the 3rd paragraph, we start to get our instructions from this particular party. So here begins the instructions, and here continues with some of the issues that the parties, or this particular party, wants to have us address. So it says, we would appreciate it if in your report you would address the following questions, colon. And then it goes on to the list of questions. Number 1, a detailed medical history. Number 2, please give us your diagnosis. And then number 3, here comes the first causation question. It says, whether or not the medical findings are consistent with the original incident or injuries claimed by, in this case, the applicant, which is Mrs. Jones. So let's think about this question. This question asks us whether or not the medical findings, in other words, the findings on physical examination, the diagnostic study findings, all of the medical findings, are consistent with the original incident or injuries claimed by Mrs. Jones. So what's behind this question? What's behind this question is the requester of the evaluation is asking us, what's the cause of Mrs. Jones's findings? What's the cause? What is the causation of Mrs. Jones's medical findings? Are Mrs. Jones's medical findings caused by the industrial injury? This is a causation question. Now, it's not preceded, you'll notice, by the word causation, colon, and then the question. That would be one formatting suggestion that I would recommend to the writer of this cover letter, but it doesn't come to us that way. But even though it doesn't come to us that way, this is clearly a causation question. And then it goes down to question number 4, and then number 5 and 6 gives us even more causation questions. It says number 5, if disability exists, is it industrially caused or aggravated? In other words, what's the cause of the disability? Is the cause of the disability related to the industrial injury? This is a causation question. It says, if industrially caused or aggravated disability exists, is it the result of a specific incident, or is it the result of a cumulative trauma injury, or both? And these are the types of causation questions that you'll find in cover letters that give you your authority to invoke causation as a complexity factor. And I'll tell you how to handle that here in just a moment. Let's take a look at another cover letter. This is a different cover letter. It continues on with questions on the page 2 of this cover letter. And there's a causation question. It says, did the employee sustain a work-related specific injury, comma, a cumulative injury, comma, or both? Question mark. And then it goes on to be even more specific with regards to this question. It says, please do not confuse work causation of injury arising out of and occurring during the course of employment with causation of permanent disability. That would be an apportionment discussion, correct? If you find work causation of injury, please identify the dates and parts of the body for each such injury, and please explain your reasoning. So the requester of this evaluation is requesting some very specific and some very detailed and some very complex medical decision making in this contained within this question. So not only does it ask for specific injury, cumulative trauma injury, or both, it says what are the dates of injury, what are the body parts of injury, and please explain your reasoning. In other words, make sure, the requester is saying, make sure that your opinion contains how and why reasoning, and that your opinion qualifies as substantial medical evidence. And in response to this particular question, your answer in the causation section of your report needs to be thorough, needs to be comprehensive, and needs to be exhaustive, and needs to be impressive in order for causation to qualify as a complexity factor. But it begins with the written request from the party or parties, and herein, these cover letters do indeed contain such requests. Finally, have page 1 of a third cover letter. It's all redacted. But you can see in this particular cover letter, first question, it asks for an addressment of causation. First question right here. It says causation, colon. Please address which body parts you find to be industrial. If you do not find a body part to be industrial, please specify the cause of the injury or symptoms. So, what is this question asking us? This question is asking us, what are Mrs. Jones's symptoms in totality throughout the entirety of her body? What are her symptoms that she's having? And of those symptoms, which of those symptoms and which of those body parts are related to the industrial injury? It says, please specify the cause of the injury or the symptoms. So herein, in this question, the requester of the report is asking for a very detailed and complex discussion. And this section of the report needs to be impressive in order to fully qualify the discussion of causation as a complexity factor. It needs to fully address and fully resolve the issues in dispute as requested by the parties. So apparently in this case, the disputed issues involve which body parts and which body symptoms. So Mrs. Jones apparently is complaining of many body parts and many body systems, but the claims administrator is wanting to know, of all of this totality, which parts of these symptoms and which body parts are we ultimately liable for? So this involves a very complex discussion. So when you see the causation questions requested of you in the cover letters that you receive, you can then invoke causation as a complexity factor. Now, in invoking causation as a complexity factor, there's 2 steps involved in this process. Step number 1, in the separate section in the beginning of your report wherein you list your use of the complexity factors, you can now list the cover letters. You can now reference the cover letters that you received. Here's the cover letters. You can now reference these cover letters underneath the causation complexity factor and cite the authority that you have to invoke causation as a complexity factor. Cite the specific requests from the party or parties requesting the report that allow you to invoke causation as a complexity factor. So let's back up just a step. The purpose of this program is for you to be able to prove to the parties that your use of the complexity factors should be reimbursed, should be properly reimbursed. So when you receive a request to address causation in your cover letters from the party or parties, you need to demonstrate to the reader of your report, which is the claims administrator, the defense attorney, the applicant attorney, you need to demonstrate to those parties that you have the authority. How do you demonstrate that you have the authority? You cite the specific requests from the cover letters that you received. So for example, under the causation complexity factor in the separate section at the beginning of your report, you would say complexity factor number 6, addressing the issue of causation upon written request of the party or parties requesting the report, period. Next sentence. The February 2, 2018 cover letter from Attorney Smith of the law firm of Smith & Williams requests, new line, number 1. Did the employee sustain a work-related specific injury, a cumulative injury, or both? Next sentence. The February 15, 2018 cover letter from Attorney Hughes from the law firm of Hughes & Bryan requests, whether or not the medical findings are consistent with the original injury or injuries claimed by Mrs. Jones. And under the causation complexity factor in the separate section at the beginning of your report, you cite your authority, you cite your sources of written requests from the parties which allow you to invoke causation as a complexity factor. So that's step one in proving that your causation complexity factor qualifies as a complexity factor. That's step one. And then step two is in the causation section of your report, which is 10, 20, 30, 40 pages later in the depths of your report. In the causation section of your report, you reiterate your authority by reciting the requests that you received from the parties. So you can simply cut and paste what you typed in under the causation complexity factor in the separate section at the beginning of the report. You can simply cut and paste that section into the causation section of your report, and then simply proceed to answer the questions that were requested of you by the parties in the causation section of your report. And in this manner, you can fully qualify causation as a complexity factor. Okay? And this can be done even prior to the face-to-face meeting with the examinee. Okay? What else can be done prior to the face-to-face meeting with the examinee? Well, how about the review of records complexity factor? The review of records, the records are something that we typically receive in advance of the face-to-face evaluation, and you can begin working on the review of records in advance of the face-to-face evaluation, and you can establish this as a complexity factor even in advance of the face-to-face evaluation. So let's talk about the review of records. Now, not every review of records that qualified medical evaluators do qualifies as a complexity factor. In fact, most review of records that I've reviewed do not qualify as a complexity factor. And if I was the claims administrator, I wouldn't pay. I wouldn't pay for any of the hours associated or any of the hours that are billed for the review of records, because doctors don't follow the law when it comes to reviewing the records. You may or may not know this, but there's 4 laws, 2 labor codes and 2 codes of regulation that govern the review of records. And most doctors simply do a non-formatted, haphazard review of records that they might use in their clinical practice, which works fine in their clinical practice, but is not specific to the California workers' compensation system and does not satisfy the requirements of the 4 laws that govern the review of records process. Okay? So in California workers' compensation, in order for your review of records to qualify as a complexity factor, it has to be done exactly according to the 4 laws. Otherwise, it's not going to get reimbursed as a complexity factor, and your report is going to be down-coded appropriately or similarly. Now, many doctors employ transcriptionists or third parties to do their review of records. And what the transcriptionist does is, with their high school education or maybe a couple years of community college education, and maybe at most a course in medical terminology under their belt, they will take the stack of medical records from the doctor and they will simply recapitulate the entirety of that document in a Microsoft Word document and then present the doctor with a written transcript of the records. And they consider this to be a review of records. And then, in order to be efficient on the doctor can then simply look at the transcript without having to go through multitudinous and voluminous pages of medical records. He can simply look at this condensed transcript and get the idea and the gist and the details of the case. Well, that does not qualify as a review of records, and I'm going to explain to you why. But to compound matters and make matters even worse, many doctors then take this transcript and then simply cut and paste this transcript into the body of their report under the review of records section. And if you look at these review of records that are done by these third-party transcriptionists, you can tell that the writing style, that the grammar, that the language, that the word selection, that the syntax is completely different from the doctor's own language in other sections of the report. In other words, you can tell that the review of records is not done by the doctor because the language is dissimilar from the language that the doctor employs in the other sections of his report. And this does not qualify as a review of records. So the review of records, you may not know this, but the review of records are governed under Labor Code 4062.3, Labor Code 4628A, and then also under California Code of Regulation 10606, and then also under California Code of Regulation 41, Section B2. So let's extract some of the key phrases from each of these laws, these 4 laws, that relate to the review of records that you need to employ and incorporate into your review of records so that your review of records can qualify as a complexity factor. Now, the review of records is almost a gift complexity factor that the parties simply give to us because most cases involve voluminous medical records that do take more than 2 hours to properly review. So this is basically a gift complexity factor, and you can capture this gift if you do it properly, according to the 4 laws that govern the process. So here's a couple of key phrases from Labor Code 4062.3D. It says that in any formal medical evaluation, the agreed or qualified medical evaluator shall identify the following. So there's the verb. We're required to identify. Identify. Okay? Number 1, all information that we received from the parties. So here they're asking us to show the parties our hands, to show the parties our cards, and to disclose and to divulge to the parties all the information that we received. And you can see where this may potentially go. Later on in deposition, you can imagine that one of the attorneys says, Doctor, I reviewed your review of records, and let me ask you, did you receive a document dated 10/2/2014 from Smith MD? And you will go through your review of records and you will see that that item is not listed, and you can confidently say, no, I did not receive that document. And the attorney can then say, well, doctor, here is a document. This must have been omitted from the records that you received. I'd like to have you review this document and issue a supplemental report. And by complying with this complexity factor, the parties know exactly what information you've been given. They also can quickly identify what information you've not been given. So we're required to identify all the information that we received. We're required to identify all the information that we reviewed in preparation of the report. So they're asking us to show our information, to show the information that we received and show the information that we reviewed. And then finally, we're supposed to identify all the information that we relied upon in the formulation of his or her opinion. So let me rephrase that. This Labor Code 4062.3D requires that we identify all information that we relied upon in the formulation of his or her opinion. So this cannot be done by a third-party transcriptionist. A third-party transcriptionist cannot include in the medical record review the information upon which you will rely in the formulation of his or her opinion. Only you as the doctor can extract the key data from the review of records that's important to you, that's important for you in formulating your opinions and conclusions later on in the body of your report. Only when you disclose to the parties that information upon which you rely for the formulation of your opinions can your review of records qualify as a complexity factor. Labor Code 4628 says it a little bit differently. It says that this labor code requires that the physician review and summarize the prior medical records. So far between these two labor codes we have 3 verbs. The first labor code required that we identify. This labor code requires that we review and summarize. These are different verbs. Identify verb simply involves listing the records that we received, listing the records that we reviewed, listing the records that we relied upon in the formulation of our opinion. That's identify. Well, what is review and what is summarize? Well, review involves reading and reviewing. Summarize includes condensing and extracting the key points. This is where most doctors fail. And this is where many doctors fail. Many doctors simply fail to summarize the documents. Rather, they simply recapitulate the entirety of the document. A recapitulation of the entirety of the document is not a summary. A summary involves you as the doctor extracting the key data from the medical records upon which your opinions and conclusions later can be based. Number 3 is California Code of Regulations 10606. This states that these reports, in other words, physicians' reports, these reports should include, where applicable, number 1, a listing of all information received from the parties, reviewed in preparation of the report, comma, or relied upon for the formulation of the physician's opinion. So here, in this section, this is what provides for the listing of outside documents, other books, other sources, other references, other information not received from the parties, but information upon which your opinion and conclusions later will be based. So the purpose of these requirements is so that you can show the parties your hands. You can show the parties the information upon which your opinion and conclusion later on in the report are based, so that the parties can look at the information, can identify the information, can assess the veracity and the applicability of the information. You disclose your hands and show your cards to the parties and give the parties a chance to work with this information to determine whether or not they have a problem with it. Okay? And it's only by showing your hands to the parties that the review of records can qualify as a complexity factor. Finally, Title 8, California Code of Regulation 41B2 says, all qualified medical evaluators, regardless of whether the injured worker is represented by an attorney, shall review all available medical and non-medical records and/or facts necessary for an accurate and objective assessment of the contested medical issues in an injured worker's case before generating a written report. It says the report must list and summarize all medical and non-medical records reviewed as part of the evaluation. Again, the verbs here are list and summarize. So here's the verbs. The verbs are identify. The verbs are review and summarize. The verbs are list. And then finally, list and summarize. So it's clear that these 4 laws require that we disclose our hands to the parties, that we list the information upon which our opinions and conclusions later on in the body of our report are based. And your opinions and conclusions later on in the body of your report should make references back to the medical records. So, for example, in one later section of your report, you may refer back to a specific citation in the medical records by stating, for example, according to the January 1st, 2017 physical examination of Smith, MD, parenthesis, see review of records above, page 7, for date of service, 1/15/18, whatever it was I said, close parenthesis. And here you refer back to the review of records. You refer back to the medical information upon which your opinion and conclusion now is based. You refer back to the information upon which you rely now for your opinions and conclusions. And it's this way, it's in this manner that the review of records serves as a tool for you to refer back and forth to, so that the parties can see whereupon your opinions and conclusions are coming from, whereupon your opinions and conclusions are based. So the review of records properly done should be referred to in later sections of your report. And many doctors simply attach this transcript which is assembled by a third party. They simply attach this review of records as an addendum to the report, not even within the body of the report, but simply as an addendum to the report. And nowhere in the report is there any reference made, there's no reference made to any specific citation within the review of records. And by requiring us to perform our review of records according to these 4 laws, the workers' compensation system is telling us how to fashion our opinions and conclusions. They're telling us to fashion our opinions and conclusions by relying on facts. What kind of facts? What kind of information should we rely? Well, part of the facts and part of the information upon which our opinions and conclusions should rely should be facts and information found within the medical records. They're asking us to refer to the medical records in providing our opinions and conclusions. So anytime you provide an opinion or conclusion that's supported in the medical records, that qualifies as a substantial opinion. And you should refer back and forth to the medical records in providing your opinions and conclusions in order to qualify your opinions and conclusions as substantial. Okay? And very few doctors are aware of these 4 laws that govern the review of records, and so their review of records simply does not qualify as a complexity factor. So, doctors, these are 2 of the complexity factors, the causation complexity factor and the review of records complexity factor, over which you have direct control. These are complexity factors that you can establish for certain and for ironclad certainty, even in advance of the face-to-face evaluation. So there's absolutely no reason that you should not be able to capture causation as a complexity factor and review of records as a complexity factor if you simply follow the procedure. So I hope that helps you. I know this will help you. You're going to start reviewing the cover letters and extracting the causation questions from the cover letters. You're going to cite the questions, the specific requests for discussions of causation in the separate section at the beginning of your report. You're going to reiterate your authority for invoking causation as a complexity factor within the causation section of your report, and that will fully capture causation as a complexity factor. And then with regards to the review of records, you simply create a table. I recommend that this be done in a table, that you create a table within the body of your report that allows you to capture review of records by satisfying all of the verbs that are required. So you satisfy the listing, you satisfy the identification, you satisfy the review and summary, not a recapitulation, a summary, and that you satisfy the verb of listing. So you satisfy those 4 verbs, and you fully capture causation as a complexity factor. And the best way to organize the review of records is in a chart tabular format. So doctors, I hope this helps you. In our next discussion, we're going to talk about additional complexity factors and how to capture those additional complexity factors, including medical research, including apportionment as a complexity factor. And we're going to spend some time talking about report preparation time and how report preparation time has changed dramatically recently, how it's expected to change dramatically in the very near future. And basically, we're going to talk about what you can rely on with regards to your report preparation time, at least in the near future, while all the uncertainty over report preparation time is being resolved by the experts, okay? So for today, this is Dr. Perry Carpenter. I want to thank you for taking the time to join me on today's video. Look forward to being with you on our very next video as well. And for now, I'm wishing you best of success in your career as a qualified medical evaluator.